My name is Lourdes Brown, and I am reading the article Why a Strong Asylum Application Matters More Than Ever, written by Mindy Daynes of Indivisible 845. The Spanish version of this article actually has a little bit of a different title. Basically, it's make sure that your asylum application is complete, but they're both basically saying the same thing. Immigration judges are now taking a stricter approach to asylum applications, Form I-589. In some cases, they're looking for reasons to deny an application, and because of this, people applying for asylum must be especially careful to make sure that every part of their application is complete. This became especially important after a March 2025 decision called Matter of Carr, CARR. In that case, the Board of Immigration Appeals, or BIA, said an immigration judge does not have to review an asylum application on its merits if the application is incomplete. The BIA explained that an application may be considered incomplete if it, 1, does not answer every question on the form, 2, is not signed, or 3, is missing required materials. The problem is that the decision does not clearly say how much detail is enough. As a result, different immigration judges may decide for themselves what makes an application complete. This has led to some difficult and sometimes unfair results. For example, even if a question does not apply to you, it is safer to write not applicable or NA instead of leaving the space blank. You should also avoid answering longer questions, such as questions about harm in your home country, by writing only, please see attached declaration. Instead, give a clear and detailed answer directly on the form. This decision is causing added stress for people who already filed an asylum application and are waiting for the hearing. If this applies to you, now is a good time to review your application with your attorney. Your attorney can help you check whether the application could be challenged as incomplete under this new interpretation. As attorneys see how judges are applying this decision, they are sharing what they learn with the rest of the legal community. That information can help you and your attorney decide whether your own application may be at risk. One question getting a lot of attention asks about the countries you, your spouse, or your children traveled through or lived in before entering the United States. If this applies to you, list each country separately. For each country, include how long you stayed, what your immigration status was there, why you left, whether you can lawfully return to live there, and whether you applied for refugee status there, and if not, why not? If you did not apply for refugee status, explain why. Judges are looking for specific answers for each country. Another issue that often comes up is whether you or your family members ever belonged to, worked with, or were connected to any organizations or groups in your home country. This could include a political party, student group, labor union, or another type of organization. If the answer is yes, explain what the group was, how you or your family member participated, whether anyone held a leadership or other position, and how long the involvement lasted. Even if the group is not central to your asylum claim, judges may still expect a detailed answer. A third question that can create some problems asks whether you or any member of your family included in the application ever committed a crime, including an immigration law violation. This question has several parts. One important detail that many people overlook is what happened at the border. If the United States Border Patrol detains you after you entered the United States somewhere other than an official port of entry, you should include that information. You should also include the dates, how long you were detained, and any other details the question asks for. These are not the only questions that can cause problems, but they are some of the most common. Even if an attorney helped you prepare your asylum application in the past, it is worth checking again. The rules and expectations are changing, and your attorney can help you look for possible weaknesses before your hearing. For instance, your attorney may be familiar with the trends in the courts where they practice. If a judge denies your asylum application because the judge says it was incomplete, you may still be able to appeal to the BIA, the Board of Immigration Appeals. For example, if the judge believed the application needed more information, the judge should have given you the chance to resubmit it. Your attorney may also be able to argue that the law requires a specific, meaningful answer to each question, not every possible detail. In some cases, a shorter answer may be reasonable if the issue was not important to your claim. Appealing an asylum denial can be expensive, stressful, and time consuming. It can also feel discouraging. Still, if you have a valid asylum claim and the ability to continue fighting, it is worthwhile to pursue an appeal. Immigration law is changing quickly, and these new expectations are difficult even for lawyers to manage. For people seeking asylum, it is very hard to handle these issues without legal help. Finding a trusted attorney can be difficult, but trusted friends, community members, or religious leaders may be able to help you find legal assistance so that you have the best chance possible.